Hi everyone, and welcome back to Bowdie Shorts, making law make sense in 15 minutes or less. In this episode, we're looking at occupiers liability. This is sometimes called a special liability regime because Parliament has stepped in and created specific rules about accidents that happen on premises. The good news is that most occupiers liability questions can be reduced to one simple question. Is the claimant a visitor or a trespasser? If you can answer that question, most of the rest of the problems become much easier. Now, by the end of this video, you'll understand who counts as an occupier, who counts as a visitor, who counts as a trespasser, and the different duties owed under the 1957 and 1984 Acts, and the main defences available. Let's get into it. So step one, visitor or trespasser. Well, every occupier's liability question should begin here. Ask, did the claimant have permission to be there? If the answer is yes, we're usually dealing with a visitor. If the answer is no, we're usually dealing with a trespasser. And that distinction matters because two different acts apply. For visitors, we're looking at the Occupiers Liability Act 1957. For trespassers and other non-visitors, we're looking at the Occupiers Liability Act 1984. Now, the biggest mistake students make is trying to analyse everything before deciding which act applies. Always classify the claimant first. So who's an occupier? Well, interestingly, occupier's liability is not really about ownership. It's about control. The courts ask who had sufficient control over the premises, and that person is likely to be the occupier. This means an occupier might be the owner, a tenant, a business operating from the premises, a contractor controlling part of a site, and there can be more than one occupier at the same time. So for SQE purposes, don't focus on legal ownership, focus on practical control. So who is a visitor? Well, visitors are people who have permission to be on the premises. That permission may be express, such as being invited into somebody's house, or implied, such as walking up a driveway to knock on the front door. Visitors can also enter because the law gives them a right to enter. For example, police officers where they have a warrant, or certain officials exercising legal powers. The important point is that visitor status can be lost. A person who exceeds their permission becomes a trespasser. So when does a visitor become a trespasser? And this is a favourite SQE exam area. Imagine a hotel guest entering a door marked staff only. The guest started as a visitor. The moment they entered the prohibited area, they became a trespasser. Likewise, a customer climbing behind a shop counter, someone attending a cinema without paying, someone entering an area outside their permission. So always ask, were they where they had permission to be? If not, their legal status may have changed. Now, when we look at visitors, we're looking at the Occupiers Liability Act 1957, and the occupier automatically owes a duty to lawful visitors, and this is known as the common duty of care. The duty is to take reasonable care to ensure visitors are reasonably safe. Notice something important. The Act does not require occupiers to make premises completely safe. It requires them to make visitors reasonably safe. And that reflects the general negligence approach of reasonableness rather than some concept of perfection. Now, when will an occupier be in breach? Well, the court applies a familiar question. Did the occupier act as a reasonable occupier would have acted? And relevant factors include the seriousness of the danger, the likelihood of injury, the cost of precautions, the practicality of precautions, and the nature of the visitor. So the approach looks very similar to what we've already seen in ordinary negligence. But we do have some special rules. Special Rule 1 applies to child visitors, and children receive greater protection. The law recognises that children are less careful than adults. They may fail to appreciate risks. They may be attracted by dangers. They may act impulsively. As a result, occupiers must expect more from themselves where children are concerned. A danger that would be obvious to an adult may not be obvious to a child, and something attractive to children may require additional precautions. For SQE purposes, remember, the younger the child, the higher the level of protection likely to be required. But what about parents? Well, this is where students sometimes overstate liability. Occupiers are entitled to expect a reasonable degree of parental supervision. So if very young children are allowed into obviously dangerous situations without supervision, parental responsibility may become relevant. The law does not make occupiers insurers against every possible accident. Let's look at special rule number 2, skilled visitors. And this is thinking about things like electricians, builders, roofers, window cleaners. And the law assumes these people understand the risks that are part of their profession. So an occupier can therefore expect them to guard against dangers that are ordinary incidents of their work. Now that reduces the burden placed on the occupier. So ask, is this a danger connected to the claimant's specialist skill? If yes, expect a lower standard from the occupier. Warnings. Can a warning discharge the occupier's duty? Yes, but only if the warning is adequate. A warning must actually make the visitor reasonably safe, and this means the court will consider how specific it was, whether it identified the real danger, whether the visitor could understand it. A sign stating danger uneven surface is generally more useful than a sign simply stating danger. The question is always, did the warning allow the visitor to avoid the risks? Now let's have a look now at independent contractors. Let's suppose the danger was created by a contractor. Can the occupier escape liability? Well, potentially yes. The occupier can discharge the duty if they acted reasonably by choosing a competent contractor, checking competence where appropriate, and checking the work where it was reasonable to do so. However, what is reasonable depends entirely on the circumstances. The more technical the work, the less likely it is the occupier can personally verify everything. So we've covered visitors. Let's look at trespassers now under the Occupiers Liability Act 1984. This is where students often get confused. The first thing to remember is a duty is not automatic. Unlike the 1957 Act, the occupier does not automatically owe a duty simply because somebody enters the premises. Certain conditions must be satisfied first. So when does a duty arise? Well, the occupier must know about the danger or have reason to believe it exists. They must know trespassers might be nearby or have reason to believe they may come near it. And they must be able reasonably to provide protection. In the circumstances, only if all 3 requirements are satisfied does a duty arise. This immediately makes it harder for trespassers to succeed in a claim compared to a visitor. So what does the duty cover? Well, there's another key distinction here. The 1984 Act protects against death and personal injury. It does not generally protect against property damage. That is an easy SQE mark because students often assume both acts work identically. They do not. State of the premises, and this is a very important limitation. Occupiers' liability focuses on dangers arising from the state of the premises. Not everything that happens on land falls within the acts. For example, a danger created by the physical condition of the land may fall within the act. A separate activity carried out by someone on the land may not. So always ask, was the injury caused by the condition of the premises? If the answer is no, ordinary negligence may become more relevant rather than occupiers' liability. So let's look at breach under the 1984 Act. So if a duty exists, the occupier must again act acts reasonably. The court considers seriousness of the danger, age of the trespasser, nature of the premises, cost of precautions, likelihood of injury. Children again receive additional protection. Warnings and barriers may be particularly important where children are likely to trespass. What defences exist then? Well, there are three key defences that arise. Consent, a claimant who knowingly and willingly accepts the risk may fail in any claim completely. Contributory negligence, a claimant who helps cause their own injury may have their damages reduced. Exclusion, now this is far more relevant under the 1957 Act than under the 1984 Act. In practice, exclusion clauses are heavily controlled, particularly where business occupiers are concerned. So what's Bowdie's bottom line? Well, every occupier's liability question begins with one question in your mind: visitor or trespasser? If the claimant is a visitor, then we're looking at the Occupiers Liability Act 1957. A duty arises automatically. It is the common duty of care, and they must make that visitor reasonably safe. If the claimant is a trespasser, then it's the Occupiers Liability Act 1984. The duty arises only if specific conditions are satisfied. It covers death and personal injury only. It focuses on dangers arising from the state of the premises. And then ask yourself, who is the occupier? Was there a danger on the premises? Was reasonable care taken? Is there a defence? If you can answer these questions in order, you've got a framework capable of dealing with almost every SQE occupiers liability problem. Thanks for watching this Bowdie Shorts. Look forward to seeing you again soon.